Hi, everyone, and welcome to week 12. We're going to finish up real property, talk about environmental law and landlord-tenant law. And you were to read those two chapters before the live class, and then attend the live class or watch this recording to take short essay 3. Short essay 3 is due by the end of next class. So for my Monday, Wednesday class, that's Wednesday at 10:30. For my Tuesday, Thursday class, that's at 10:30 on Thursday. So I'm just going to walk through the chapters. And the first chapter talks about real estate and environmental law. And when we talk about real estate, we're really talking about uh, the estates rather than people. So I'll give you an example of that later, but here's a good figure that kind of lays out um, a look at real estate from its nature and the estates, which is the first thing we'll talk about, incidental rights and easements, or regulation of real estate. And that is either land use regulation, and that could be through tort law, private agreement, or by the government. And then environmental law, which is the end of this chapter. And those 4 areas that are listed there are really the areas of environmental law that relate primarily to real estate. So when we talk about estates, we're talking about freehold estates or leasehold estates. So if you own property right now, then you have a freehold estate. And if you lease it, it is called a leasehold estate. So you have an estate. And if you own the largest estate, the biggest bundle of rights you can have, you own it in fee simple absolute. So a fee simple absolute owner can sell the land, gift it, divide it, use it, anything that's lawful they can do with the land. However, there are some ways to, when you grant real estate, give less than fee simple absolute to the grantee. So in this examples, we'll be using A as the grantor, the one making the grant, B as the grantee, the one the grant is made to. And you could say A to B, that would be fee simple absolute. And if you said A to B unless, or A to B a life estate, those are types of fee simple defeasibles. So I'm going to try sharing my whiteboard here for a minute. So if we just said from A to B, where A is the grantor and B is the grantee, that is fee simple absolute. Pretty straightforward. There's no reservations. There's no, then something else happens, right? But if we said, as the example here in the chapter, A is the grantor. I think they said it was Warbucks grants to Nightingale, some property used for hospital, and if B stopped using it for hospital, then it would go back to the grantor. So that's one type of fee simple absolute. So let me erase that one. All right, so another type of fee simple defeasible is a life estate. And in our example, we would say from A to B, but we wouldn't stop there. We would say for the life of B. And some of you might say, well, then how's that any different than a fee simple absolute? Because B can only use it during the life. And that is, the difference is what happens after B dies. So typically, if we said from A to B, then when B dies, the property would go to B's heirs. However, we said A to B for the life of B, then back to A, then the heirs would get nothing, right? So let me erase that part here. So this A to B for the life of B, then back to A, raises a couple questions. The first one is, what if A predeceases B? Well, that's why we need to think about them in terms of estates. It would be A to B for life of B, then back to the estate of A. If A was deceased, then that would go on to A's heirs, right? So this A to B for life of B, then back to A is called a reversion, right? So there's part of the chapter which talks about present and future interest. B has a present interest of a life estate, and A has a future interest, which is called a reversion or a reversionary interest, because it reverts back to the original grantor. But that's not the only type of life estate. We could also say A to B for the life of B, then on to C, right? And in that case, C would have a future interest, and that future interest would be called a remainder, because it doesn't revert back to the original grantor, it goes on to somebody else. Some people have referred to this as the bad son-in-law grant. A, from me to my darling daughter B, and if she dies, I don't want it to go to my bad son-in-law, I want it to go on to my other darling daughter C. So this is an example of the present interest, and then C's future interest. All right, so now I'm going to jump back to the chapter here. That's fee simple to feasible, that's life estate. And B in our example was a life tenant, which basically means B can be on the property, take care of the property, but they can't waste the property because it needs to go on to someone else, right? So if you're an heir of B, you would want to know that B had a life estate because you're not going to get this property. All right, we talked about future interest, or reversion, or remainder. And then it says rights, incident, possession, and ownership. And really, when we think about real estate, we typically think about the land, things attached to the land, trees, buildings, homes. But the chapter says that we own the airspace above it, and we owe the minerals and things below it, right? So the right to airspace isn't absolute. We shouldn't be shooting at planes flying over our property, but we have certain rights to use the air, to enjoy it, to prevent others from interfering with our use and enjoyment of the airspace. And to the depths. So, you see this sometimes where there's oil or gas or water or something below the land. And we could even separate our rights to land and say, we'll occupy the land, but someone else will have a right to the minerals below the land. A right to water. So this is an essay question, and it talks about, probably this chart is the best way of addressing that. And it really depends upon which side of the country you live on. And water is more scarce on the west side versus the eastern side of the country. So Western states use a prior appropriation, and it gives you an example of that in that it talks about, it gives you some examples of if somebody were to use it upstream or have prior appropriation over here, then that is an example of what happens in the Western states. They would get to do that, and then the person who's downstream, the person who used it subsequent, is out of luck. Versus in the Eastern states, there's some natural flow or reasonable use theories. The idea is it's not the first in time, but the person upstream could use it but not prevent it from going on to somebody who's downstream. So it talks about that in your chapter. All right, easements. So an easement is a right to go onto someone else's land that goes with the land. It's permanent, versus what they refer to as a license, which is a right to go onto someone's land, which is personal to some person. It's revocable. It doesn't go with the land. So if I sold land to someone else and it had an easement on it, that easement goes with the land. But if I sold land and I'd given somebody permission to come onto that land, that doesn't necessarily transfer to the new landowner. So that's the key differences between an easement and a license. You know, they talk about even negative easements. So some places where there's a lot of solar power, if I built a solar collection system and then my neighbor tried to block it, what rights would I have? My neighbor can use their airspace. So one of the things I might do is reach an agreement there where I have an easement to the sunlight, or in some states they even have laws that relate to not blocking solar power. All right, it talks about dominant serving estates. This is probably a good diagram to show you that. So a lot of times, especially in Michigan, you'll see like subdivisions, and outside the subdivision is a farm, and usually that is farmland was all split up, and not all of the pieces of property are on the road. You also see this in that mom and dad own this big parcel of property and they decide to deed it to their kids. And when they do that, they reserve this easement across it, which is a driveway, right? So if this wasn't here, they wouldn't be able to get out to the road. So the dominant tenement is the tenement that has the right to the easement. The servient tenement is the land where the easement is. So green actually owns all this property, but blue has a right to go over it to get to this road, not for other purposes, not to live on, to build on, to occupy, but for ingress and egress across that strip there. All right, and it also talks about easements and gross and easements appurtenant. Uh, and easement appurtenant means this, that they are adjoining, and easement and gross means there's an easement. Maybe this is for utilities, and the utility company isn't adjoining, it's somewhere else. All right, and then it talks about different ways those easements are created and how they're used. And then the next part of the chapter talks about regulation of land use, and says, is that diagram we showed you laid out, that it's controlled by tort law, private agreement, and the government, right? And so we talked about eminent domain at the start of the semester, and it comes back when we talk about real property law. So if it's a landowner's activity and they sue in tort, they might sue for a trespass or a nuisance. And trespass means coming onto property, or coming onto property and not leaving the property. And a nuisance would be interfering with the right to property, and it may not be coming onto property. So they mention, you know, as an example, loud noises or odors or things like that could be considered a nuisance. And then to talk about liability when there's injury to somebody, and talk about how that typically there's no liability to a trespasser who comes on the property. But there is this idea that if the trespasser is a child, that they may not know better, that they may be attracted to something. For example, a pool would be considered an attractive nuisance. And a lot of statutes have requirements around what you need to do to pool to keep it safe, even though somebody wasn't invited onto your premises, because kids will be drawn to things like that. We talked about licenses. Well, licensees and invitees, we're talking about, like in the business setting, you know, what obligation do we have to people we invite, public we invite into our premises? And I would say the two major categories are, we have a duty to keep them safe, and we have a duty to warn. So they come into our premises and the floor is wet, we should have a sign that tells them that. And if there is water on the floor, we should mop it up. All right, and then private agreement. So if you live in a subdivision, or your parents live in a subdivision, you might know about this, that there are restrictive covenants that can be put in place to prevent you from building certain things on certain size land. You know, we're talking about things like sheds, fences. So that would be between parties. And then the last thing they talk about is public control of land and this idea of eminent domain. So under the Fifth Amendment, it says property can be taken for public use uh, as long as there is just compensation. And so that, you know, raises some issues. Is it really for public use? Is it really the government that's taking the property? Is it really just or fair compensation? All right, it talks about zoning in your chapter, how that is another way of regulating what happens with real property and how governments deal with non-conforming uses, including a variance of zoning laws. All right, the last part of the chapter talks about environmental law. And, you know, most of this is federal law and, you know, might leave you the idea that that is all environmental law is, but there's a lot of state law too. So we can't cover every state in the chapter, but you know, most of these laws at the federal level are pretty clear what they cover. The Clean Air Act has to do with clean air, Clean Water Act, etc. There's also laws in this part of the chapter relating to the disposal of hazardous waste. And one part of the chapter I want to show you is under the National Environmental Policy Act. It talks about the environmental impact statement. So the essays ask about the purposes or the things that need to be covered in the environmental impact statement. They are listed here. So it must include the detail about the environmental impact, anything that's unavoidable, any adverse effects, you know, all that is listed there. And that's one of the essay questions. So, you know, I would say there's criminal and civil penalties for violations of most of these laws. Um, it talks about the Superfund in your chapter and the idea that you could have joint and several liability, including, you know, whoever generated the waste, whoever transported the waste, who ever disposed of the waste on the land. Even subsequent landowners could have liability under this act. So that's that chapter. And then landlord and tenant law, you know, it talks about what are the various types of leasehold estates, how are they created and extended, the rights and duties of landlords and tenants, and potential liability. There is a liability question about landlords on the short essays. So I would say for the final, one of the things that comes up is I might ask a question like, what is a lease called for a specific period of time? And a lot of people will say periodic tenancy. But in fact, it says an estate for years is for definite beginning and ending date. So like a lease for 1 year would be considered an estate for years. Down here, it talks about a periodic tenancy, and that has to do with the fact that it's renewed periodically, not that it's for some specific length of time. So don't get those two confused. And then it talks about a tenancy at will and the fact that even if it's not for a specific period of time, there's no written tenancy, that, you know, as long as the parties agree that there's a tenancy or act like there is a tenancy, it could even be implied that there is one. It talks about creating leasehold estates and how the statute of frauds might impact that. Sometimes oral statute frauds might require them to be in writing. If they are required to be in writing, what is required to be in the lease? And then it talks about rights and duties of the landlord. You know, I would say that the three things that a landlord is doing when they lease property is they're granting possession for a period of time to a tenant, they're warranting that it's in habitable condition, and that they are not going to interfere with the use. Because, you know, they don't transfer title, but they do give exclusive possession and use, you know, subject to what the law says a landlord can enter into what the parties agree to. But generally, just because the landlord owns the property doesn't mean they can come in anytime and do whatever they want. So it talks about how what relates to possession, this warranty of habitability, this idea that it used to be caveat emptor, or the idea that once the tenant signed, what they got. But now it's more of a, you know, you have to rent out something that's in good condition that somebody can inhabit. And then non-interference with use talks about this covenant of quiet and enjoyment. It doesn't mean everything's going to be absolutely quiet, but it means that the tenant's use of the property during the term of the leasehold estate is not interfered with. And there's some different remedies, which, ultimately depends on the state you're in. Sometimes people ask me, well, can I withhold rent? And, the chapter talks about that briefly, but that's really something you want to look at in terms of Michigan law and talk to an attorney about. It talks about proper eviction and constructive eviction and the different types of damages that you might see. It talks about rights and duties of the tenant. They have a duty contractually, legally to pay rent. Talks about security deposits and how to restore the premises to the landlord. So lots in there about the rights and duties of both parties, as well as the remedies in case there is a breach. Another one that comes up is, what if the landlord transfers interest? I would say the general rule for that is just, you got a new landlord. So the landlord sells the property, the leasehold goes with the property. In terms of the tenant's interest, the one that usually comes up there is this idea of an assignment or a sublease. And in an assignment, we're talking about the entire lease. In a sublease, we're talking about a term. And it really depends a lot on state law and what the parties have agreed to. A landlord will not want to just have the tenant sign a lease and then assign it to some third party, or sublease a portion without knowing who they are, doing credit checks, those type of things. So when we talk about an assignment, we're talking about the tenant's entire interest. If we're talking about a sublease, we're talking about less than. And then this one is the one that's on the short essays. It talks about landlord's tort liability. And the general rule is, if the landlord gives exclusive control over to the tenant, then the tenant has liability if something happens on the premises. And we're not talking about common areas, but areas under the control of the tenant. But these are the exceptions to that general rule. So when the essays ask you, what are the exceptions? You don't have to go into detail about what the general rule is. You want to talk about these exceptions, hidden dangers that the landlord knew about, dangers to people off the premises at least for admitting the public, where the landlord retains control of the premises, and faulty repairs. So that's what I'm looking for there. And then there's some cases at the end of the chapter if you need clarification about anything that's covered. So go into Blackboard when you have attended or watched the video Mark reviewed, and I will show you where the essays are at. I'm going to shrink this down a little bit, and you go into the week 12 folder, and then you will see these short essays, and I'm just going to go through the questions real quick here. It says use complete sentences, answer all the questions, no required word count. You get the most points by applying the law to specific facts. In this case, I've asked you to pull some things directly from the chapter. The first question, what are the exceptions to the general rule relating to the liability of the landlord? So we just went over that. Question 2, differentiate between riparian use and prior appropriation, which I went over that when I showed you that diagram. And then the last question, state the various purposes of an environmental impact statement. And we walked through that. So you can go through this and save all your answers, but when you have completed all your answers, make sure you hit save and submit. If you have any questions or problems, you can email me, or you can email and arrange for a live chat. And with that, I'm gonna end this recording, and I hope you all are doing well.